Welcome back to the second segment of Contract Law, Contents of a Contract. We did consider last time the difference between a term and a representation, and just before the break I told you we would continue with conditions, warranties and innominate terms. Now, contractual terms can be conditions, they can be warranties, or they can be that very interesting innominate terms. Traditionally, contractual terms were classed either as conditions or warranties. This whole category of innominate terms was created or first raised in the Hong Kong fur shipping case. It is important for parties to correctly identify which terms are to be conditions and which are to be warranties. Because where there is a breach of contract, it is important to determine which type of term has been breached in order to establish what remedy is available. Because you've got to determine, is it a term which may give rise to certain types of remedies, or is it a representation, in which case the representation has to meet certain criteria in order for you to be able to get any sort of relief in any event. Now let's consider a condition. A condition is a major term of the contract. Word, of course, is that is a fundamental term of the contract, because it is a kind of term which goes to the root of the contract. It's a kind of term which, if you do not, if there is a breach, it goes to the actual heart of the contract, and therefore it means that you will no doubt have to ensure that you can treat yourself as discharged. Now, if a condition is breached, the innocent party is entitled to repudiate, meaning end the contract, and claim damages. Let's consider a couple of cases. In Poussard and Spars in 1876, Madame Poussard entered a contract to perform as an opera singer for 3 months. Now, she became ill 5 days before the opening night and was not able to perform the first 4 nights. Now, Spars replaced her with another opera singer. The court said that Madame Poussard was in breach of condition and Spars was entitled to end the contract. She missed the opening night, which was the most important performance, as all the critics and the publicity would be based on that night. So the issue is not whether or not she became ill. The fact was that her inability to be able to perform for the first 4 nights were so fundamental that it was that Spars could treat himself as discharged from the contract, meaning that he would have no obligations under it. Now, warranties, on the other hand, are minor terms of a contract which are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damages, but he cannot just end the contract. Important case here, of course, is Bettini and Guy, 1876. Now, opera was very big in the late 19th century there, so this is another opera case. Bettini agreed by contract to perform as an opera singer for a 3-month period. Now, he became ill and missed 6 days of rehearsals. The employer, of course, terminated him and replaced him with another opera singer. The court said that this was obviously slightly different from the Poussard and Spars case. He said Bettini was in breach of a warranty only, and therefore the employer was not entitled to end the contract. Missing the rehearsals did not go to the root of the contract. So the point is, there has to be a distinction between a first night performance and the rehearsal. I mean, nowadays you have, big performers who they don't even go to their own rehearsals. Yes, we may have Michael Jackson who died whilst he was rehearsing, but when you look at, by and large, most people turn up on the last 2 nights, I imagine. So the courts were of the view that, yes, he did miss 6 nights, but this did not warrant, in the context of the entire thing, for him to be terminated. Yes, part of the contract was that he would also be rehearsing, but they considered it was not fundamental enough, entitling the claimant to seek discharge of the contract. Now, innominate terms rather, what are they? Innominate terms was established in the case of Hong Kong Fur Shipping. Now, rather than classifying the terms as conditions or warranties, what an innominate term does is to approach it from the point of view of looking at the effect of the breach and the question whether the innocent party to the breach was deprived of substantially the whole benefit of the contract. It is only where the innocent party was substantially deprived of the whole benefit will they then be able to treat the contract as at an end. Because the idea is that there may be a term that the parties have not expressly said or laid out that it is a condition or a warranty. Equally, it may not be such that it goes to the root, but it is important. But is it important enough to be a condition, or is it less important in order to amount to a warranty? Well, in the case itself of Hong Kong Fur, a ship was chartered to the defendants for a 2-year period. The agreement included a term that the ship would be seaworthy throughout the period of the hire. The problems developed with the engine of the ship and the engine crew were of course incompetent as well. Consequently, the ship was out of service for a 5-week period and then a further 15-week period. The defendants treated this as a breach of condition and ended the contract. The claimants brought an action for wrongful repudiation, arguing the term relating to seaworthiness was not a condition of the contract. Now, the court said that the defendants were liable for wrongful repudiation. The court introduced this whole innominate terms approach. They said rather than seeking to classify the term itself or classifying the term as a condition or a warranty, the court would look to the effect of the breach and ask if the breach had substantially deprived the innocent party of the whole benefit of the contract. Only where this is answered yes, is it then to be a breach of a condition. So it's sort of like a precursor. You look at its effect, and if it is that the effect is pretty onerous, then we go down the route of a condition. If it is less so, we go down the route of a warranty. Now, 20 weeks out of a 2-year contract period did not substantially deprive the defendants of the whole benefit, and therefore they were not entitled to repudiate the contract. Now, this approach has certainly been criticized for sacrificing certainty, and I have mentioned before that when you look at the law, certainty is really what is of prime importance, sometimes, unfortunately, to the detriment of any perceived justice. The idea is you really should know going into court what has been found on the basis of precedent in order to give you some degree of knowledge of what might occur in court. The case was, of course, criticized to say that it had made the whole situation somewhat uncertain. Also, the innocent party may well be liable for wrongful repudiation if they treat the contract as at an end where it is found that the breach did not deprive them of substantially the whole benefit of the contract. Now, even where the parties have themselves classified the term in the contract as a condition, the courts can hold that it was in fact only a minor term, and therefore a breach of that term would not give rise to the right to repudiate the contract. Now, repudiate the contract means basically to say that you have breached and therefore I can treat myself as not having any obligations under it and treat myself as discharged from the contract. Now, if you and I draft a contract and I say, right, it is a condition that you turn up on time to work, it is a condition that you use your own equipment whilst at work, the court may very well look to exactly what the agreement is between the parties and determine that we don't really care if you call it a condition. Based on what the circumstances are, it isn't. Now, there are 2 cases that I want you to contrast. The first is Schuler and Wickman tools in 1974. Now, Schuler were manufacturers of certain tools and Wickman were a sales company granted the sole right to sell these tools manufactured by Schuler. A term of the contract between the parties was described in the contract as being a condition, and it provided that Wickman would send a salesperson to each named company once a week to solicit sales. Now, this imposed an obligation to make 1,400 visits in total. Wickman failed to make some of the visits, and Schuler terminated the contract for breach of condition. The court said that despite the fact the contract had expressly stated the term was a condition, the House of Lords said that it was only a warranty. In the case of Lombard North Central and Butterworth, on the other hand, the contrasting case, we see the defendant leasing a computer from the claimant. Now, the claimant was to pay £584 by 20 installments every 3 months. Now, a term of the lease agreement provided that punctual payment was required, and breach of this term would entitle the lessor to terminate the agreement. The defendant, of course, got into arrears with the installments, and the claimant took possession of the computer and sold it for £175. The claimant sued the defendant, claiming the arrears and all the future payments, which amounted to £6,869 in total. The court said that the term relating to prompt payment was a condition. The parties, by their agreement, had demonstrated that prompt payment was an essential term, and the consequences of the breach was clearly set out. Now, Lord Justice Nichols said that even one late payment would entitle the lessor to terminate irrespective of the effect of the breach. The need for certainty in commercial transactions is highlighted certainly in the case of Mihalis Angelos, and the owners of a ship there was what the case was about. Now, the ship was chartered to the defendant to use for carriage of cargo. A clause in the agreement said the ship was expected to be ready to load on the 1st of July. In fact, the owners had no grounds to believing the ship would be ready to load on that date, as it was in Hong Kong at the time and would not be ready until at least the 14th of July. And in fact, it was not ready at that date. The defendant cancelled the contract on the 17th of July. The cargo that they expected to be carrying had not arrived due to the bombing of a railway in Vietnam. The ship owners brought an action against the defendant. The point here, of course, is neither party was ready, but the fact was that they were supposed to have been ready at a particular time. Okay? Now, the ship owners brought an action against the defendants for anticipatory breach. An anticipatory breach, of course, is where you say you don't have to wait until somebody breaches a contract in order to bring an action. If you're in an agreement for me to sell you my house by January 1st, and by November 1st, I have sold it on to X, you don't have to wait until January 1st to bring an action. You can certainly bring it because I have already, you're looking at an anticipatory breach. It is highly unlikely I'm going to be able to transfer it to you on January 1st. Now, the defendants argued that the claimant was in breach of the condition of the contract by not being ready to load on the specified date. Well, the courts held that the expected ready-to-load clause was a condition despite the fact that it had caused no loss to the defendants. The classification as a condition was said to be because of the need for commercial certainty in shipping contracts. Now, what we've seen there, of course, is looking at a situation where the courts will consider the certainty in particular cases. And those particular cases, of course, are commercial cases. Now, if we consider terms from a different angle, how they may be implied into a contract. Well, terms may be implied into a contract by the common law. Now, the courts are normally very reluctant to imply terms into a contract at common law. It is the parties' role to agree the terms of their particular agreement. It has been famously said that the courts are not there to fix a bad bargain. That is why the courts say the parties have made their agreement. So the parties are just looking at, what is the dispute here as to the agreement you've made. So implying terms is not generally a route the court wants to take, but sometimes it has to. Now, it is not generally considered to be the role of the courts to rewrite a contract for the parties. It's all about freedom of contract. Freedom of contract prevails. You and I can make any contract we like as long as it is legal, of course. Now, there are some limited circumstances where the court will imply a term into a contract at common law. Now, You may imply, for example, a term through custom. A term may actually be implied in fact, or a term may be implied at law. Now, if you look at a term which is implied through custom, this is where a particular term is prevalent in a trade, and the courts may imply a term into a contract of the same type in that trade. There's also terms implied through custom, and again, where a particular term is prevalent in a trade or custom, the courts will similarly imply there. Now, a case, Housen and Warren, the claimant was a farmer who had a tenancy on the defendant's field. The claimant had planted corn and barley on the field and worked the fields to ensure the crops would grow. Now, before the field was due to be harvested, the tenancy was terminated. The claimant then submitted a bill to the defendant for the work and cost of seeds spent on the field, as was customary in farming tenancies. The defendant refused to pay, saying there was nothing in the tenancy agreeing or saying that in the agreement, and that compensation was not payable as far as he was concerned. The court, though, implied a term into the tenancy providing for compensation for the work and expenses undertaken in growing the crops. The term was implied as it was common practice for farming tenancies to contain such a clause. We'll take a short break in terms of these in relation to these terms, and when we come back after the break, we will continue with terms which are implied by the courts and see terms implied in fact and in